Good morning and a very warm welcome to our fourth Construction and Engineering webinar of 2022. This is our winter update, which I think we'll all agree this week it's starting to be a bit more wintry outside. I am Catherine Andrews. I'm a partner in the Construction and Engineering team, and we're really grateful for you all joining us this morning. If I could have the next slide, please. So hopefully most of you will be familiar with Burkitt's, so I won't spend long on this section, but just to say this is a bit of information about the firm. We're a top 50 full service law firm with 5 offices across the east of England and London. So I just wanted to take the opportunity to introduce you to our panel this morning. First of all, we have Darren Rolfe, who is a legal director in our construction and engineering team, and she specialises in development and project work and is currently dealing with a lot of building safety queries, hence her involvement today. We've then got our guest speaker from another team within Burkitt's, and today that is James Humphreys, who's a senior associate in the firm's property litigation team. James is also dealing with a lot of inquiries relating to building safety, and therefore we thought it would be interesting to hear about the impact of the Act from his perspective, acting for leaseholders and the like. And finally, we have Rebecca Childs, who is a chartered legal executive, again in the construction and engineering team, who specialises in dispute work, and she's going to look at some case law for us. So welcome to all the panel, and if I can have the next slide, please. So just a brief agenda for this morning. As I mentioned, Darren is going to do an update on the Building Safety Act and see where we've got to with the various changes. Then James will look at the Act from a property litigator's perspective. And finally, we'll have Rebecca doing the case law update on a few of the most recent interesting cases in the construction field. And without further ado, I will now hand over to Darren to talk to us about the Building Safety Act. Thank you, Darren.
Thank you, Catherine. Okay, so just a quick recap in case anybody's actually missed the Building Safety Act. Obviously, it arose out of the Grenfell fire disaster. The government decided that it was time to improve the safety of buildings and the safety and security of people in those buildings. So it brought the Act in. It went through the usual committee and drafting process and took a while, and there were a lot of changes. But finally, it got royal assent in April of this year. There are 170 provisions of the Act, which make it one of the bigger ones on the statute book, and they are coming into force in sections that didn't all come in at one time. The reason for that is simply to do with what it is that it covers in terms of structural things like new regulators and new activities that need time to actually be put in place. Broadly, the Act changes the legal landscape on recovering losses from unsafe building and sets up these new structures for regulating buildings. May I have the next slide, please? So what's in force now? Primary legislation acts usually require some form of secondary legislation, what are known as regulations, to define the detail, set out procedures, and look into the actual practicality of how it's going to be enforced. The regulations are usually done by the relevant Secretary of State, so that it's not as though Parliament spends its time arguing about whether this detail or not is due to be included. So all of the provisions of the Building Safety Act will be coming into force via sets of regulations. There are 2 that have come into force so far that are directly under the Building Safety Act, and one that is sort of allied to the Building Safety Act. So the first one is the BSA, because I'm not going to keep repeating Building Safety Act, BSA 2022, Commencement number 1, Transitional and Savings Provisions Regulations, nice snappy title, and that's the statutory instrument number there should you wish to look it up. And the second one under the BSA is the Commencement number 2 regulations. Then after I've gone through what those mean, I'm just going to have a look at that last one that's very much allied with the BSA provisions. So may I have the next slide, please? Okay, so the Commencement number 1 regulations. The actual date of the regulations was 19th of May, but again, as with the main Act, different parts are coming into force or have come into force at different times. These regulations covered firstly putting the new building safety regulator on a statutory footing, so setting up the concept of having a building safety regulators and office. That came into force on the 28th of June. A lot of these provisions came into force on the 28th of June, but not all of them. That's now in the process of being set up and organised so that it will be up and running properly sometime next year. The regulations also inserted the definition of higher risk buildings into the Building Act. The way that the Act has worked is basically by amending a lot of the things that are in two existing acts: the Building Act 1984, which is where the building regs come out of, and the Defective Premises Act 1972, which relates to dwellings, habitable dwellings, and what they need to be. So the first thing that was brought in under these regulations was to amend the definition of this higher risk building into the Building Act, so that the provisions of the BSA are then part of the Building Act 1984. The difficulty with that, and I'll say this now rather than later on, is that the relevance of that is to do with the change in the limitation periods that we looked at last webinar, in that you can now sue not just under sort of normal 12 years liability, but retrospectively 30 years and prospectively 15 years. So the main thing with the Building Act was to bring in these and the Defective Premises Act was to bring in these new limitation periods to allow more claims to be brought, basically. The difficulty, of course, is that the part of the Building Act under which you would bring a claim, which is Section 38, is actually still not in force. It was expected that it would be brought into force under these regulations, but it wasn't. So at the moment, the limitation action in that respect is purely theoretical. The next thing that this regulation brought in was the building liability orders, which I'm going to talk about a bit more in a moment. It introduced Section 38, which amended the requirements for insurance of approved inspectors. The regime for approved inspectors has changed quite a lot, and there is a slight interesting situation whereby they've removed the requirements currently in place for approved inspectors insurance, but they haven't actually put the new ones properly into place yet. So it's a bit transitory at the moment, but that's very much in hand. The regulations brought in Section 160, the rights of social housing occupants to escalate complaint directly to the Housing Ombudsman Service. This is something that previously had only been open to in respect to private residential landlords, but it was felt that it was appropriate now for social housing tenants also to be able to go to the Ombudsman, and that didn't come into force until October. And then, as I've already mentioned, one of the most important things was the changes to the limitation periods under the DPA and the Building Act, so that claimants have a greater ability to bring claims in respect of problems with unsafe cladding and the like. Next slide, please. The other two things that were brought in under the first regs were the introduction of new cause of action on construction products. Now, we looked at this last webinar, and it is a specific cause of action whereby people can sue if construction products are themselves defective or have been installed or marketed in a way that have made them be used for something that is inappropriate and unsafe. So that is now in place already. I don't think we've seen any cases come through yet on that, but no doubt if we do, Rebecca will update us on that. And the final thing it did was it strengthened the powers of the Architects Registration Board. This is in respect of architects' competencies and training requirements, and it gave more power to the board to strike off, I suppose is the word, architects and require further training. Next slide, please. So the second set of regulations brings into force Section 126, 129 of the Act, which deals with building industry schemes. Now, it says that a scheme may be established for any purpose connecting with securing the safety of people or improving the standard of buildings. the idea then is that developers or landlords or whoever can be forced to join a scheme that will improve these things. The schemes will be established by the government, by the Secretary of State, and in establishing them, it means that they must prescribe who the eligible people are, and the condition that those people must meet in order to become a member of the scheme. And it's not so much that they want to exclude persons from it. It's more a question of achieving the appropriate standards to be involved. Next slide, please. So the membership conditions that may be prescribed for particular schemes require the members then to remedy defects in buildings. So if you are a member of a scheme and you have been told to remedy defects in a building, then if you don't do it, there are you can be prevented from developing, for example. You can be made to make financial contributions towards the costs associated with the remedying defects. You can be told to use in prescribed cases particular construction products in order to again improve safety. You can be required to provide information to the Secretary of State or any other person, but they haven't actually defined who that is yet. So we're assuming it's a kind of auditory governmental type agency rather than just random people. There's the competence or conduct of any individual connected with an eligible person who's a member of a scheme. So you could have people who are not considered appropriate, and whether persons with whom an eligible person contracts, so members of the scheme contracts, are members of the scheme. So it's to do with ensuring standards and behaviours to improve safety of buildings, basically. Next slide, please. Section 128, and this is the sort of the downside of the other side of this coin for the scheme, is that persons in the scheme may therefore be prohibited from carrying out the development of land. So they can actually stop people and say, no, your track record's not good enough. We don't believe you take adequate precautions in accordance in respect of safety, and you will therefore not be able to develop land. And they're doing this by preventing them basically from applying either for planning permission or for applying for building regs. And if they are applied for by other people, preventing them from being handed over to those people. So it's quite a practical way of preventing development, because it means that prescribed persons simply can't get the necessary statutory approvals to go ahead with a scheme. Next slide, please. So the way a persons are to be prevented from applying for building regs is under section 129. So it prohibits the person from applying for building regs, from giving an initial notice, from granting approval to that person, passing of plans deposited by the person, the acceptance of an initial notice given by the person. My teeth in today. They can't get a final certificate. They can't give a prescribed document. So it's very thorough in terms of how they are prescribing it. It's going to be impossible basically for people to get around this if they have become a prohibited person and they want to try. Next slide, please. So one of the things that I mentioned that had come into force under the commencement #1 transition and savings revision regulations was building liability orders. BLOs are a very interesting move that this Act has brought in. They are designed to prevent developers from escaping liability for defects that are applicable under the Act, simply because they used an SPV, or indeed the company they used has gone under. And it's a way of ensuring that the developers who are in a position that they should be making a contribution to or remedying defects can't simply shrug their shoulders and walk away. So the High Court will grant a building liability orders on the basis of if it considers that it's just and equitable to do so. And what it does is it extends the liability of what's called a body corporate, so it's either a limited company or an LLP, to any of its associates, making them jointly and severally liable. I mean, what this does really is it breaches the corporate veil around a limited company or an LLP and says, no, it's not as ring-fenced as it always has been. Actually, your associates can be made liable for the wrongs that you have committed. Now, in this context, an associate is either a sister company or a parent company, something within the group anyway. And if the original body is dissolved, has become insolvent, ceased to trade, you can still get a building liability order in respect of its associates. So just because, for example, a developer had used an SPV doesn't mean that the group company gets away with it. They can be made liable for the building liability order. And once the building liability order is in place, that means that the tenants who have suffered loss because of the problems can then sue whoever the order states is the liable person. So this will apply to claims made both under the defective premises and the Building Act parts of the BSA, and note section 38 still not being enforced. And it can be applied for by a person who has been prescribed by the leaseholders protections influence regulations stated there, which is basically just lays out the type of people who would have sufficient interest on a legal basis to make the application to the High Court. So leaseholders who have qualifying leases in relevant buildings with relevant defects and various other things to do with how the actual development company, the landlords operate. Schedule 8 of the Act sets it out in very, very clear detail how you calculate whether or not the company is one that you can get a building liability order against. At the same time as a relevant person prescribed by the regulations there as asking for a building liability order, they can also ask the court to order that corporate information is disclosed, because it may be that they can't actually find out from public information who might be associated and whether or not their net worth meets the threshold and the various other things prescribed by Schedule 8. So it's not a toothless thing where the company can go, well, you just don't know enough about us. The court can actually order them to disclose that information, so it can be decided whether or not a building liability order can be applied for. You should remember that this is not the same as a building remediation order, which is actually the order that says they've got to do something about the defects themselves. The liability order merely puts in place on a legal basis the fact that the relevant company is liable for that. So the BLO is the forerunner before a remediation order. Next slide, please. So what's coming into force next? This is not strictly BSA. This is actually to do with the Fire Safety Act, but it sits very much alongside the BSA. So the new regulatory reform Fire Safety Order 2005, Fire Safety Order Section 24, to give it its full snappy title, gives the government the power to impose obligations on what are known as responsible persons or others, so broadly managing agents, building owners, those kinds of people. And this applies to all premises, including workplaces and common parts of multi-occupied residential buildings. The obligations are fairly straightforward in terms of what they mean, but on a practical point, they are possibly slightly more complicated in that there is a requirement that the building responsible person provides information to fire and rescue services and to residents in respect of things like escape routes and what the buildings are made of. And this includes as-built drawings, which of course, if these buildings are up to 30 years old, it might actually be an issue. So I think there are going to be practical problems with this, and this comes into force in January. So that's going to be a problem. Next slide, please. So that's my quick run through what's currently in force and what's coming up. So I'd like to hand over now to James, who's going to look at the Building Safety Act from a property litigator's point of view. Thank you.
Brilliant, thanks, Darren. As Darren said, my team's involvement in fire safety issues and specifically now the Building Safety Act relates primarily to how it impacts the landlord and tenant relationship. So my part of the webinar really relates to existing buildings where fire safety issues have been identified and how the Act now impacts on how those issues are addressed. And so really kind of a practical overview of the impact of the Act. A key part of the Act is that it seeks to protect leaseholders. And you'll see on the slide that the main areas of impact are that the Act imposes new provisions relating to existing residential leaseholders. What you can and cannot charge through the service charge now has to be read not just in accordance with the lease itself, but in terms of what the Act says that you can now do. It also has a retrospective effect, which means that it rewrites history in terms of remedial works that have already been undertaken and the cost of those works. And clearly this could have huge financial consequences for building owners and landlords who may have legally, if controversially, recovered costs via the service charge from leaseholders, but now find themselves in a position where those costs may have to be refunded. The other point to note by way of introduction is that, as Darren has said, the Act is very long, it's very wide-ranging, and was introduced in a bit of a hurry in the end. And in my view, it shows. As it's also very new, there's not much in the way of precedent or indication on how various parts of the Act should be interpreted, which means that the inconsistencies, gaps, and complications are many. And it may take some time for those issues to be resolved. Next slide, please. Before getting into the detail of the Act, it's worth reminding ourselves how we got here, as that helps to understand how we ended up with this bit of legislation, which represents such a big change in approach, but was drafted so quickly and with so many apparent gaps. Ultimately, the Act is a culmination of increased scrutiny on safety of high-rise buildings in the UK since the Grenfell Tower fire in 2017. And in the immediate aftermath of the Grenfell fire, the focus was on what was called ACM cladding, which is a particular type of material used in manufacture of cladding. And it was quickly established that many buildings across the country had been constructed using this same material. Some building owners were quick to replace the cladding with a safer alternative and charged the cost to leaseholders via the service charge, often at extortionate cost. And I'm sure that we've all seen in the news reports of leaseholders faced with service charge demands of tens of thousands of pounds to cover the cost of those works. Now, at that time, the government, whilst disapproving of that approach, essentially permitted landlords to do it. There was a statement which said that developers and building owners should do the right thing and pay for remediation costs. And whilst that was no doubt well-meaning, at the time there was nothing to prevent building owners from doing it. And so this was very much the leaseholder pays phase of the government's response. Some building owners, however, were not so quick to act, which caused issues in itself. For every news story where leaseholders were faced with massive service charge bills, there was another where leaseholders were essentially trapped in their flats, unable to sell or remortgage given the safety issues that had been found to exist and hadn't yet been remediated. And I think that the efficacy of the government's response at that stage is best summarised by what has happened since then. So moving on to the next slide, where we then saw a raft of funding introduced by the government. So the government pays phase. The first round of funding supported the cost of removing and replacing this ACM cladding, first from social housing and then privately owned buildings. It was then discovered that ACM cladding really was the tip of the iceberg, and that there were lots of other materials and issues with high-rise buildings that were causing fire safety issues. And this led to the introduction of the Building Safety Fund, funding removal of dangerous non-ACM materials and addressing other defects. And initially this was £1 billion worth of funding, and then there was a further £3.5 billion the following year. And that fund remains open now. It reopened in conjunction with the introduction of the Building Safety Act earlier this year. Next slide, please. The funding has at all times come with various catches though. Some buildings were excluded where the building owner had already started works before the funding was announced. and so it was no help for those leaseholders who had already been subject to service charge demands. There are also issues of exclusions, both in terms of who could apply, where the developers responsible owned the building, for instance, they couldn't apply for funding, but also exclusions in terms of what funding would cover. One particular example here was balconies, and it's always been quite difficult to see the justification for treating balconies any differently from, for instance, cladding, other than perhaps because the funding otherwise wouldn't have gone anywhere near far enough. There's been several reported fires which have spread across timber balconies, and the issue is similar to cladding in that it was a design choice made by the developer of the building as part of its original construction. Funding applications are also reported to be still taking a very long time to process, and applicants have to meet various requirements in order to benefit from the fund, including obtaining various fire risk assessments when there is a well-publicised shortage of professionals able to carry out those assessments at present. Next slide, please. So these issues, I think it's fair to say, heralded the beginning of what could be termed the developer pays phase of the government's response. And earlier this year, this kind of was kick-started by the government introducing the developer pledge. This was targeted at larger developers and forced many developers to agree to remediate buildings at their own cost or risk having future planning applications refused. And I know that's something that Darren referred to in her part of the talk that's now been enshrined in the Building Safety Act. But stepping back to earlier this year, it was quite an extraordinary step for the government to have taken when it wasn't based at the time in any legislation, but simply a letter sent to developers by Michael Gove asking developers to agree to this. Next slide, please. But in some ways, it's that approach which now underpins the leaseholder protections that we now see in the Act. Developer pays has now almost become anyone but leaseholder pays, as we'll see when looking at the Act in a bit more detail. Essentially, the position now can be summarised as leaseholders cannot be asked to pay for any cladding-based remediation and can only be asked to pay for non-cladding works in very specific circumstances, and there are various enforcement methods now available to leaseholders to ensure that this happens in practice. Next slide, please. So, turning to the Act itself then, and who qualifies for these new leaseholder protections. The first requirement is that there has to be a relevant building. The building has to be at least 11 metres tall, not 18 metres as was required for earlier funding applications. The building must also contain at least 2 flats and must not be leaseholder owned. There also has to be a qualifying lease, essentially a long lease of over 21 years where a premium is paid rather than a rent, and it must have a service charge. It also needs to have been granted prior to 14th of February this year, which is the crucial cut-off date for these protections to apply. There are also certain ownership requirements, and essentially anyone that owns more than 3 properties in the UK is excluded from the leaseholder protections. And whilst the intention there is clearly to prioritise protection for those who simply own and live in a flat affected by fire safety issues, this does seem to operate quite arbitrarily. And it feels a very sharp distinction to draw between people who own 3 properties who fully benefit from the protections and those who own more than 3 who get absolutely no benefit at all. Next slide, please. There also has to be a relevant defect, and this is where we really arrive at the kind of the first crucial definition that you see in this part of the Act. And the first requirement here is that the defect has to relate to the original construction of the building. And the phrase used in the Act is something done or not done, or something used or not used as part of that construction. And that needs to cause a building safety risk, either risking spread of fire or the collapse of the building or part of it. This is a pretty wide definition on the face of it and brings plenty of defects into scope of the Act not previously covered by funding. For example, balconies. However, it's also wide enough that it's not always going to be straightforward to work out what is and isn't covered. There's scope to argue whether a defect truly relates to the original construction, And I've been advising recently on timber features on a building which, whilst in principle they represent a fire risk because they're timber, but in this case they were rotting and needed replacement as part of general maintenance. So it's not clear in those circumstances whether they should fall within scope of the Act or not. Next slide, please. So having undertaken the task of working out whether your defect is a relevant defect for the purpose of the Act, we then arrive at the key provisions of the Act, which say what happens to the cost of remediating those defects. And perhaps the single most significant provision of the Act is that it's now enshrined in legislation that costs connected to the remediation of cladding defects are never recoverable from leaseholders. And this is really full circle from the government's initial response to the cladding crisis, where leaseholders were left to pay for remediation of these defects. Interestingly though, having just explained the requirements that people must have a qualifying lease, it's not clear that actually that having a qualifying lease is a requirement for this particular protection to apply. The wording of the Act suggests that cladding costs will be the responsibility of the developer or building owner, regardless of the type of tenant or the number of properties they own. And this is backed up in the explanatory notes to the Act, which brings commercial leases into scope and social housing providers as well. Next slide, please. The costs connected to remediation of non-cladding defects is slightly more nuanced. Those costs are still recoverable, but only in certain circumstances and if certain conditions are met. You must also here have a qualifying lease in order to benefit. Non-qualifying leases will have to pay in any event. And what the Act does is it creates what they've referred to as the waterfall system for determining who is liable for costs. The first condition here is that there is a blanket requirement that no cost can be recovered if the landlord is linked to the developer. And this ensures that the developer remains primarily liable where still involved in the building. If that condition is not met, then the landlord may be able to recover, but only if their net worth is below a certain threshold. And that's calculated on a per building basis. So it's the net worth of the landlord essentially divided by the number of buildings that they own. The next requirement is that the landlord can only recover from leaseholders if the value of those leases meets a certain valuation threshold. So that requires leaseholders essentially to show what the value of their property is. And clearly the previous two conditions require information to be provided by both leaseholder and landlord, and in the landlord's case certainly requires provision of quite detailed accounting and financial information to leaseholders in order for them to justify recovery of costs. The Act introduces deeds of certificate, as they've been called, which put the onus on the parties to provide the required information or risk simply being deemed not to qualify. If the landlord can meet all those conditions, there will in any event be a cap on the amount that can be charged to leaseholders. The amount varies depending on whether the building is in London or not and the value of the leases within the building, but in most cases it's going to be £10,000. As we've seen, that's by no means going to guarantee to cover all the cost of remediation. So even if the landlord can get this far, it's very likely that they're going to be looking at a shortfall where there are widespread fire safety issues. Next slide, please. The Act also introduces means of enforcing these protections for leaseholders. Both of them require an application to the first tier tribunal. So firstly, remediation orders, which Darren touched on, seek to address the remaining inactive landlords by forcing them to carry out remediation works. The application can be brought by leaseholders, but also by local authorities and the fire service. In practice, I think we're going to see that this is going to be a leaseholder application, but it's interesting that they have widened it to include those other bodies. Interestingly, these orders are Oh no, sorry. So remediation orders designed to force landlords to carry out works. We then have remediation contribution orders, which seek to force landlords or developers to pay for those works. And interestingly, those orders are said to apply retrospectively. And that means that where leaseholders have already been charged for remedial works and the landlord has not willingly refunded those costs in light of the introduction of the Act, the leaseholders can request a refund via an application to the tribunal. These orders can also be used to pass liability up the chain. So if the landlord has been subject to a remediation contribution order, but the developer is still solvent and in existence, the landlord can in turn apply for a remediation contribution order from the developer where the defect is their fault. Next slide, please. Finally, on this last substantive slide, I've just highlighted a few additional relevant provisions which affect the landlord and tenant relationship. The interesting one here is that leases are deemed to be amended to permit the landlord to deal with building safety measures and that the cost can be included in the service charge. My interpretation of this is that whilst the Act is very tough on landlords in terms of pre-existing defects arising from the construction of the building, the purpose of this provision is to ensure that landlords aren't discouraged from taking steps to prevent future fire safety risks that arise, and that where proper to do so, the landlords are able to charge leaseholders for those works via the service charge in the usual way, and really kind of emphasising safety above all else. I've also put a question mark there on the last point on the slide, criminal liability, because earlier in the year, a letter went round to the Association for Residential Managing Agents, threatening criminal liability for wrongly pursuing service charges where prohibited by the Act. Now, for my part, I can't see within the Act where that criminal liability comes from for that particular offence, as it were. So it's perhaps something to keep an eye out for in the coming months. Next slide, please. So to sum up then, what does this all mean in practice? I mean, this has been a very brief run through, but it's clear that the provisions in the Act and these leaseholder protections override the landlord and tenant relationship and fundamentally change the way in which leases drafted possibly many years ago must now be interpreted. It's also worth noting that this is a piece of generally quite leaseholder-friendly legislation, which has been introduced into an already leaseholder-friendly context as far as service charges are concerned. Landlords are already required to show that costs are reasonable and recoverable under the terms of the lease, and this can be challenged by leaseholders in the first-tier tribunal. And what we've seen in recent years generally is a trend towards the tribunal taking a fairly restrictive approach and not allowing recovery of costs not specifically covered by the lease. And it seems to me that the Act will only reinforce that approach where building safety issues are concerned. It's also the case that the additional obligations contained in the Act generally create potential liability for landlords, building owners and managing agents, which in many cases they're going to be ill-equipped to deal with, particularly resident management companies and RTM companies. So there are, it seems to me, potentially huge implications in terms of the exposure to the cost of remedial works no longer chargeable to leaseholders, the additional administration and the specialist knowledge required to assess building safety risks. And it will be really interesting to see how that plays out in the coming years. Thanks very much for listening to my part of the webinar. I'm now going to hand over to Rebecca, who's going to do a roundup of recent cases in this area.
Thanks, James. Yes, I'm going to do a case law update. If I could have the first slide, please. I don't think you can really have a Building Safety Act webinar without talking about these two cases. I will only do that very briefly because I'm sure we all know them by now. But the first was Malali, which was a Court of Appeal decision following Grenfell. And in that case, the design and build contractor was held liable for £8 million worth of costs, both in waking watches and replacement of defective cladding, which kind of set the scene for the Building Safety Act. And then following that, we had Orchard Plaza, which was the same design and build contractor held liable for fire safety defects, but in this case, they were held liable under a collateral warranty. They tried to say that because it was under a collateral warranty, they shouldn't be liable, and the judge said, no, that's not right. So from this point, it was pretty clear that the courts were going to be quite hard on contractors for dealing with these kinds of issues. So if I could have the next slide, please. So all of us have kind of mentioned the fact that there's some issues coming out of the practicalities of the Building Safety Act. So this isn't so much an update as a foresight, but the Building Safety Act does create some issues in relation to limitation. It's just one of the points that I thought I'd mention. So if you've got cases that are coming to court potentially 30 years later, there's going to be issues with lack of documents, particularly when it doesn't really quite comply with GDPR, probably, to still have those documents 30 years on. Potentially also lack of witnesses, lack of insurance. So we're going to need some guidance from the court on these things, but until cases start coming through, we're not going to get that guidance. So I was thinking about what might happen, and as James mentioned, potentially the Building Safety Act will be used more as a threat than a reality. And also we might get some more pre-action disclosure applications, and I've got a couple of example cases on those 2 points. But ultimately, whether these cases come through remains to be seen because of issues like this, where the limitation period, if you're relying on it, sort of 29 years on, whether in reality those cases will come through, we don't know yet. So if I could have the next slide, please. So this is my first example case, and it is to do with failure to fix cladding. It's been widely reported as the first case in this kind of sphere, the first legal action over the failure to fix cladding. So the government wrote to the developer and owner of a tower block to say that they needed to fix the cladding within 21 days, or they would force them to do so under the Act. And as James said, there's a lot of issues around how the Act is supposed to work and obligations. So the building owner said that we've been in conversation, we've been trying to get clarity on this, and we just don't have it yet. And also the property was registered in 2020 with the building fund, but the agreement still isn't signed, so they can't get the funding that they need. So there are clearly issues around this, but the government are going to take a stand, and they are trying to use these tactics to try to force building owners to take action. And it'll be interesting to see if they take it a step further away from these threats and actually do take action against these owners. So if I could have the next slide, please. So my other potential option was pre-action disclosure applications. So for anyone that doesn't know what a pre-action disclosure application is, it is what it says on the tin. It is an application for disclosure before proceedings are issued in a claim. So assuming the other side doesn't agree and just give you the documents, it will go to court. And if the court agree with you, they will give an order to force the other side to make those, to provide those documents if they've got them. So I thought it's possible that people might try and use this to get documents in cases where they don't have them because of the passage of time. But this case suggests that's not really going to be the best option, because the judge said that actually in this case, both parties were struggling to get hold of the documents. And so in those circumstances, it just wasn't going to be reasonable to place the burden of getting those documents solely on the defendant. So really, I don't think that's going to help too much in those circumstances. It might be different if one of the parties held all the documents, the other party never had any. That might be a bit different, probably quite unusual in these kinds of cases. So in those situations, it might help, but otherwise, probably not. So yeah, maybe not the golden ticket that when the idea popped in my head, I thought it might be. So if we could have the next slide, please. So this is a case that wasn't brought under the Building Safety Act, but it does stick with the theme slightly on fire-related issues. So there was works done to a hospital, and during the course of those works, the fire strategy changed. So there was due to be a 60-minute fire compartmentation around the electricity substation in plant room 2. But this provision was removed, so the risk was higher than would normally be acceptable in the as-built building. So as a result of that, the claimant sought damages for the remediation costs, and those damages were in the order of 6.2 million for a two-stage scheme of remediation works. The contractor argued that they'd complied with the contract because they'd adopted the fire safety strategy, which had been approved by the trust, and that was the amended version. They also said that the claimant wasn't actually going to complete the works, and they said that because this case had been rumbling on for a long time before it reached trial, and they hadn't taken any steps to begin those works, which they said indicated they were never going to. And they also said that they thought you could complete remediation works much cheaper. So for the phase one, they said that there was an option to install like a sprinkler system effectively for 500,000, and that would be sufficient. So the court had quite a few things to look at here, and they said, firstly, they accepted that the regulations were breached. So that was win number one for the claimant. And then they said that, yes, the fire safety strategy had been approved by the claimant, but they said that actually the claimant didn't have the detail that they needed to properly consider it at the point that they approved it. And so there wasn't any, and they also weren't given any justification for why the design had been changed. So although the strategy had been approved, the court said that actually that doesn't change the fact that the regulations have been breached, and it doesn't mean that the parties agreed to depart from the main contractual requirements. So win number two for the claimant, and that effectively meant that they had won their claim. It just then came down to how much they were going to be awarded in damages. So the first argument, as I said, was that the works shouldn't be paid for at all because the claimant wasn't going to do that. The judge said that they thought the works would be completed, and they said that because although there had been a delay, that delay had been explained clearly what they were doing in that time, so keep your records. And also they said that it was reasonable in the circumstances where the defendant was just flatly denying liability to wait until judgment to start those remediation works. So that argument failed. And finally, the last argument that the remedial works could be done a lot cheaper. The judge did look at it, and they said, based on expert evidence, that the works were reasonable, what the claimant had claimed for, and they decided that based on expert evidence. And they also looked at the alternative scheme that was put forward by the defendant, and they said that actually, if that scheme was implemented, it still wouldn't comply with the regulations. So the claimant won on all fronts, and they were awarded their costs. In the end, I think actually, in a case like this, if you've got remedial works that need to be done and you're waiting for an order from the court, you're waiting for trial, in cases where the remediation scheme is so expensive, that might be reasonable based on this case. But if you've got quite a significantly cheaper remedial scheme, that might not quite be enough to rely on this case to wait. So I had got a couple more slides to run through, but we are running out of time, and I want to make sure we've got time for your questions. So they aren't actually building safety related either, so you might be pleased about this. But we'll skip the next two slides if we can, and I'll hand back over to Catherine so that we've got time to go through your questions. If she's there.
Brilliant, thank you. Thanks all. That was all really helpful. Just to confirm, we will be, as I said at the beginning, sending out the slides and recordings. So if there's anything on those final cases that is of interest and people want to discuss, please feel free to do so. So thank you all for sending through your questions. If I can pick up some of those now with the panel, please. James, there's one that's come in for you to ask whether there's been any enforcement action taken yet under the Act.
No, really. As far as I'm aware, the only form of enforcement that I'm aware of is actually the case that Rebecca alluded to about Grey GR Limited partnership, where I think when you read the summary of it, there's been some very serious delay on their part in actually doing anything about quite serious defects, and the government have actually taken the initiative there to commence enforcement proceedings against them. but I'm not yet aware of any kind of leaseholder initiated enforcement action, kind of taking account of the remediation contribution orders and remediation orders that I mentioned. So yeah, watch this space, I think, in terms of enforcement along those lines.
Thanks. While we're with you, there was another question around the effect of the position on with EWS1 forms.
Yeah, so I mean, EWS1 forms have been problematic, let's say, over the last kind of year, 18 months or so. The Building Safety Act doesn't directly affect the position. They are a product of the mortgage lending market, really, and depending on the requirements of particular lenders, may still be required by anyone looking to sell or remortgage. They may need that, and it is still the case that there is no legal requirement to have them, which makes it quite difficult where landlords haven't yet obtained one and leaseholders need one to satisfy their lender. There is still no legal mechanism for getting them to have it, and the Building Safety Act does not change that.
Thank you. Darren, if I can pose a question to you. Someone's just asked for a bit more clarity around the difference between a building liability order and a building remediation order, please.
Yes, the building liability order is asking the court to make a statement that a body, corporate, sister company, associated company, whatever, is also liable for the costs involved with remedying defects in appropriate buildings and appropriate defects, and so that it can be sort of two parts. Basically, it can ask for information about the company to be given, so that the leaseholder can calculate the Schedule 8 requirements that James mentioned about whether or not it's the value is of the necessary threshold value of the company, and then it can simply give yes, this associated company is liable. So it's a statement from the court of who is liable for the costs, whereas the remediation order is an order from the court to do the remediation fundamentally. So it's a slightly different thing.
The next stage, yeah. Thank you. And another one, Darren, if I could ask you, was relating to the comments you made on the fire safety regulations, and the question was about what difficulties you might find yourself in if you haven't got the information that you're being asked to give.
Yeah, it is difficult because the fire safety regulations require there's the list of the information that needs to be made available both to the fire service and to the tenants, and it's practical things. It's structural information about the building, escape routes, how it was built, what it was built of, and in a lot of these cases, as Rebecca said, it's a question of evidence because it's a question of the documents not being around. But it does say in the regulations that the kind of get out of jail free card, as it were, is that you have to have that available, find that information, hand it over as much as practicable, basically. So if you can't get hold of it, you're not going to get thrown in jail or anything instead, but you do have to try.
And show that you've tried, presumably.
Yes, you've tried, yes. Yeah.
Yeah, thank you. So sort of moving to that point from Rebecca's point of view, Rebecca, there's also been a question about how you think the court might cope with the situation where there isn't the evidence available, given the timescales and the limitation periods.
Yeah, so obviously the court's first port of call is documents. That's generally where we start. But if you don't have any documents, we might be looking at witness evidence, and it'll come down to who's most credible. But if there's neither, you'd be looking at expert evidence on points if that can be used. And actually one of the cases I was going to mention is Barkby Real Estate Developments and Cornerstone. And that was slightly different because there wasn't a contract in place there, which is why they needed expert evidence. But it just shows how experts can be utilised in these situations. So, but if you haven't got documents, you haven't got witnesses, and experts aren't likely to be able to help, is it actually going to get to court? I think you'd be quite a brave party and with very deep pockets if you wanted to bring a case to court with no real evidence. And I should also have mentioned, now that I'm on, the last case I talked about, St James's Oncology, there's quite a lot more detail to that case, and we are going to be sending around a sort of article about that case. So at the end of this webinar, you can click a little button and you'll be added to our mailing list to receive those things on our survey. So if you wanted any more on that, you can get it. Thank you
once again for joining us today. We'll be setting up our quarterly webinars for 2023 soon, so watch this space, and we'll let you know when those are going to kick off next year. So thanks again for everyone, and we'll see you in the new year. Thank you.